All right. So everyone, we're starting our trial up at 10. So who is ready? All right. And Mr. Brobot, what's your client's name?
Lopez.
All right. Mr. Lopez? All right, court is calling 2023 CR 8809 State versus Robert C. Lopez. Can I have parties announced for the record for the state? For the defense?
Robert Brabach for Lopez.
And are you Mr. Lopez?
Yes, ma'am.
We're here today for sentencing. According to your plea bargain agreement, the state is silent on your applications. They're taking in consideration 2023 CR 8810. And there's an affirmative finding of family violence. Did both parties have a chance to review the PSI report and TAP evaluation state?
Yes, Your Honor.
Yes, ma'am, we did.
Any objections?
No objections.
All right. So the reason we were scheduled actually to have this hearing yesterday, but he had a Tacoma interview or some sort of interview that was occurring. Probation, do you know the update on that?
DTRF approved and big approved.
Okay. All right, so in reviewing your PSI report, so this was an offense against his mother.
Yes, ma'am.
So the defendant has mental health issues, major mental health issues. Plus, on top of that, we have drug issues. The mother wants him to have the help he needs, but she doesn't want to have contact with you. So until, that may change, but for now, she's afraid of you because of what happened on this particular day. I'm aware that you have schizophrenia. And I know that previously he was found incompetent.
Yes, ma'am. He was found I think that's the reason he's been in detention for over 640 days.
Yes. So I know they put you to the state hospital to see if you would regain competency. So you did regain competency. So now the issue becomes, what do I do with you? The court understands that sometimes people have mental health issues, and mental health issues, people really have no control over those. Especially I understand with schizophrenia. But here's the thing, you are a person that is going to have to be on medication due to your schizophrenia. You cannot use drugs. And I understand that sometimes people who have mental health issues, they use drugs to compensate for whatever is going on. They don't like the medication that they're on because they say that there are side effects to it. But you are going to, if there are side effects to your medication, you're going to have to let the doctor know, because based upon your history and based upon what I'm seeing, you are a person who becomes violent when you're not on your medication. All right. So your mom doesn't want you back at the home. You're not allowed to contact your mom or reach out to your mom. If at some point your mom reaches out to the state and says, I would like to have some contact with my son, then we can approach that at that time. I'm going to grant your application. And the reason why I'm granting it is because, one, I know that schizophrenia is something that people have no control over. Two, your mother wants you to get the help that you need. Three, prison isn't necessarily going to give that to you. But what I'm telling you, if you contact your mom, sending her a Mother's Day card, sending her a Christmas card, sending I'm sorry card, that's going to be a violation of your probation. Do you understand? So what I'm going to do so that we can keep track of him, I'm going to grant his application for deferred adjudication, and I'm going to place you on deferred adjudication for 8 years. What that means is you're going to be under the court supervision for potentially 8 years. If you violate any of these conditions, you're looking at 10 years in the prison. And I'm telling you right now, prison is not the best place for mental health. And as you're aware, the jail is not a mental health facility, but because the legislature has decided they're not spending money for mental health and new hospitals, that's where you usually get your mental health treatment. You understand? All right. This is what the court will do. The court will sentence you to 8 years deferred adjudication. I'm going to order placement at DDRF. Take in consideration 2023 CR 8810. There's an affirmative finding of family violence. There is to be no contact with Elizabeth Velasquez and plus as a matter of fact, with regards to contacting that address, you're not even allowed to be on that street. Do you understand?
Mhm.
I'm sorry?
Yes, ma'am.
Okay. There's to be regular reporting by Zoom or in person, regular random UAs. Do you receive SSI or no?
No, ma'am.
All right. There's to be proof of employment within 40 days of release. There's to be no employment as a home health care provider or with minors. There's to be no contact, no unsupervised contact with minors or the elderly. I'm going to want field visits once he's released, 1 time per month for 8 months. And Ms. Abrams, when he's released from GDRF, is he automatically placed on mixed supervision?
I would ask them. Sure.
All right, there's going to be mixed supervision upon release. And there's to be GPS until further notice upon release. Waive GPS fees. And counsel, with that, we'll see how he's doing.
Okay,
If he's doing well, once he's released, then the court will consider removing GPS.
okay.
And do you have any children?
I have one.
What's the age?
He's 9.
All right. There's going to be 200 hours of community service restitution. I'm going to order parenting classes. Once parenting classes are completed, the community service hours will be deemed satisfied. Probation, is there anything else?
But part of this is concerned what type of practice you are.
I'll do partial for employment and medical appointments. And of course, if he has to report to probation.
Thank you.
All right, is there anything else you need from the court in order to be successful?
No, my one.
All right, and there's an affirmative finding of family violence. All right, did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
Yes, sir.
Yes, ma'am.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you get out the court's permission to appeal. Because this is an affirmative finding of family violence, you're not allowed to own or possess any weapons or ammunition. if you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes, ma'am.
All right, we can go off the record. In this court, communication is key, and it's doubly key for you because of your mental health issues. You need to always make sure that you stay in contact with your probation officer. If for some reason you can't reach your probation officer, you can always come back to the court. You understand? Do you have any questions about what's expected of you?
I'd have to go to DDR
Yes, you're gonna have to go to DDRF.
or,
This will be good for you.
Here's the thing. I know people don't like being on lockdown, but here are your choices. You can be on lockdown and improve yourself, or you can be on lockdown at the prison. If you're on lockdown at the prison, honestly, prison is supposed to be about rehabilitation, but really to get rehabilitated in prison, you have to 100% want it because nobody's looking out. You understand?
yeah.
All right. Here's the thing. I'm picking up some vibes from you, and let me explain something to you. You are in the position you're in because of your actions. That's where we are. And I'm trying to do something to help you.
No,
Now, what I could have done, I could have sent you to prison. Okay?
I understand. Thank you.
All right, you're welcome. And I'm serious. If you need anything and you feel as though probation isn't addressing it, you can always come back to court or let your probation officer know that you want to speak to the judge, and we'll put it on the docket and hear from you, okay?
I just wanted to say, I've been like, incarcerated for like a year,
Mhm.
or 13 months.
Yes.
I'm not, I think it takes a while I know it takes a while to go to DDRF.
Oh, no, the biggest thing about DDRF is actually getting approved for it.
Yes.
And they've already said that you're approved for it. That's where the time comes
Okay.
in.
Or,
You're approved for it.
But what I can tell you is what took so long is we can't go forward on criminal cases when someone is deemed to be incompetent, because being incompetent means you don't understand your case, you don't have a rational understanding of the facts. And so there's a wait time to transfer from the jail to the state hospital to regain competency. And the law is the law. And the law says that if someone has a violent offense and they're incompetent, they have to be transferred to the state hospital. And so you have to wait till there's availability at the state hospital to transfer you. So that's where we are.
Yeah.
But if you need
You're
anything,
approved.
just let the court know. I'm serious about that, okay?
Okay.
All right, thank you.
I think, you know.
Yes, ma'am.
You're welcome.
Thank you, Judge.
You're
I'm
welcome.
impressed how thorough you are understanding the mental health.
Thank you so much, Mr. Burrock, and you have a good one. Let me get you your dismissal.
Okay. This will be good for him.
Oh,
He doesn't
yes.
seem to understand that.
Well, I would represent a lot of people who had mental health issues, and believe it or not, it's really easier to represent people who have mental health issues because you can understand, okay, this is why this is happening. So,
Yeah, you could see that.
yes.
Have a
All
good
right, thank
weekend,
you.
Judge.
You too. Michael DeLeon, who do you have?
Judge, I got Mr. Vasquez, Stephen. We were waiting for Garahan.
Oh,
Our agreement is with him.
he said that you already know the offer.
Yeah.
And that you can let the state know.
Okay, sounds good.
Oh, here, come on. Huh? He said for me to snack. You want to snack with us or hit? I know, I'm not into that. But I'll do it for the sake of our questions. So Deputy Makia, yesterday, my brother sent me cake. Yes. What? I'm telling you, it's the birth month, right?
It's a really good cake.
He did different flavors of the little bitty bundt cakes. And then I had the big vanilla cake. So my mom called me and said, my brothers want to know, what type of cake does she like?
So good.
So Judge, we're ready on Mr. Vasquez at the courts.
Just give me 2 minutes to put this in the system and then I will take you out. And Ms. Abrams, I'll give you time to do his conditions.
This one, hopefully what's going on.
This lady if you want.
Okay.
She knows everything. Was here at 8:15.
506.
Okay.
Am I right?
No, you're good. Sure.
Right here.
Are these usable? Okay. I know
This
there's
is
one
mine.
court where I was gonna do it and they were like, John,
You're
working
pull it up. Oh, really?
Computer with you.
It's electronic. Sometimes it's so faulty.
I'm ready when you are.
All right, just give me a moment.
Oh my God, that's when they're in the bomb shelter. But Sean knows all the music to it too. Grease too, when they're in the bomb shelter. Really?
That's all.
That's in your head?
Yes.
Let's do it for our country.
But we still say that Grease 2 is better than Grease 1.
No,
No.
Yes.
Maybe.
Who said
No.
that?
No.
I do.
the music,
What's wrong with you?
That's crazy.
I think the music is good, but not the full script.
It is better.
Michelle Pfeiffer's.
Oh my God.
You know, I never liked the scene when they go to the bowling alley. She never takes off her sunglasses.
It's like this,
The whole time she's wearing sunglasses for the whole
and
scene.
chewing gum.
Because she's cool.
Nobody else was wearing sunglasses but her.
Because she's an individual.
Because she's the leader of the pack, they never do conformity.
Thank you. You know what I think? They are actually having, Michael, they're having a talent show for the Christmas thing.
Uh-huh.
We should go. And we should have sort of like, like the Sharks and the Jets, but we should have Grease 1, Grease 2, a little mix it up. And you know what's gonna bring the house down for us Grease 2 people? Who's that guy? That's what we're gonna
That
say.
guy.
We're gonna sing that song.
That's the one.
For a
And we
minute.
can even sing the Christmas song. Grease 1 doesn't have a Christmas song. Grease 2, they do the 4 season.
The calendar girls,
Yes.
I'll be your girl for the season.
Oh my God.
We should get Frankie back in there.
I like her.
Frankie's still purple.
Whoops, he'll perform.
He's still
Okay.
purple.
You pay him, he'll show up.
Okay, I'm gonna
Does he
reach out to
actually
him.
sing?
You know what? That could be
He's
our
up there.
secret weapon. All right, Stephen Vasquez. Oh, did I accident give you Stephen Vasquez
I
paperwork in
think
there?
so. So they get in there.
Come on. All right. Hello.
Hello, man. Happy belated birthday.
Oh, no, it's not belated. I celebrate the entire month, so
There you go.
we're all good.
Well, happy birthday.
Thank you so much. What's better, Grease 1 or Grease 2? I think Grease 2.
I'm older.
All right. Court is calling 2021 CR 4321, State versus Stephen Vasquez. Can I have parties announced for the record for the state?
Alexandria Box for the state.
Michael DeLeon for Mr. Vasquez.
Are you Mr. Vasquez?
Yes, I am, Your Honor.
Did you review the document entitled Motion to Enter Adjudication of Guilt and Revoke Community Supervision with your attorney? Did you understand it?
Unfortunately, I did, Your Honor.
Well, unfortunately,
Well, I wish I didn't. I mean, if stupidity was a defense, I'd be here.
okay.
Yeah, well, yeah, I did review it.
All right. Are you the same Stephen Vasquez who was placed on deferred adjudication in 2021 CR 4321 for the offense of aggravated assault with a deadly weapon on November 15th, 2021 for a period of 5 years? Is that you?
Yes, ma'am.
All right, state.
On or about the third day of August 2022 in Bexar County, Texas, the defendant, Stephen Vasquez, failed to provide proof of employment to the supervision officer within 48 hours in violation of condition number 3.
How do you plead to that?
True,
True.
Your Honor.
Okay. State? Do you waive the other allegations?
Yes, Your Honor.
Any objections to the state's waivers?
No objections, Your Honor.
All right, did you understand by pleading true to violation of condition number 3, the court could find it true, grant the motion, find you guilty and sentence you up to 20 years in prison and up to $10,000 fine?
Yes, Your Honor.
Knowing that, do you still wish to plead true to violation of condition number 3?
Yes, Your Honor.
Court will find violation of condition number 3 true. Is there a proposed agreement?
There is, Your Honor. Our proposed agreement between us and the state is to revoke Mr. Vasquez and give him 4 years in the prison.
All right, is that the agreement?
That is the agreement, Your Honor.
All right, is that your understanding of the agreement?
Yes, ma'am.
Are you asking the court to follow that agreement?
Yes, unfortunately, yes, ma'am.
All right, are you waiving your right to appeal?
I am, Your Honor.
All right. And probation, is this the recommendation for probation revocation?
Judge, the recommendation listed on the court summary indicates state ISF cognitive followed by IS.
All right, well, can we go off the record for a moment?
Within 48 hours of that change.
Okay,
And I did have employment, but I had to report to the UA hotline. And
Alright.
it was a conflict of interest and they fired me, so it's just a big old mess. I apologize.
all right, so here's the thing. It sounds like he's saying number 3 with explanation. So is there another violation, number 4?
We can do 4.
All right, let's proceed with violation number 4 then.
In Bear County, Texas, the defendant, Stephen Vasquez, did then and there fail to report to the 187th District Court on August 1st, 2022, as directed by the court in violation of condition number 4.
How do you plead to that? True or not true?
True, Your Honor.
All right, again, did you understand by pleading true to violation of condition number 4, the court could find it true, grant the motion, find you guilty, and sentence you up to 20 years in prison and up to $10,000 fine?
Yeah, I do, Your Honor.
Knowing that, do you still wish to plead true to violation of condition number 4?
Yes, ma'am.
Then, with regards to violation of condition number 3, are you withdrawing your plea of true for that violation?
Yes.
All right. Then the court will note for the record that the court is not considering violation of condition number 3. The defendant has withdrawn his plea of true and state, are you waiving all other allegations with the exception of violation of condition number 4?
Yes, Your Honor.
Now, is there a proposed agreement?
There is.
And what is that agreement?
The agreement is to revoke and sentence him to 4 years.
That's our agreement, Your Honor. We asked the court to follow that. In addition, Mr. Vasquez would like to apologize to the court for admittedly messing up on his deferred adjudication, and he wants to take full responsibility.
All right. All right, and again, you're asking me to follow this agreement?
Yes, ma'am.
And are you waiving your right to appeal?
Absolutely, ma'am.
All right, the court will follow your agreement. The court is finding violation of condition number 4 true. The court will find you guilty, revoke, sentence you to 4 years in the prison. There's an affirmative finding of deadly weapon. There's to be no contact with Deanda, Deanda. I'm sorry, it's Deanda. First name, Daisy. Jonathan Pena, P-E-N-A, 5934 and 5930 Valley Branch. All right. Is there anything else with regards to sentencing from either side?
No, Your Honor, we thank the court for the court's time.
All right. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney?
Yes,
Did you
I did, Your Honor.
understand it?
Yes, Your Honor, I did.
All right,
I think I have
counsel.
that back time, Your Honor, for real.
I'll give you credit for any time served.
Thank you.
Counsel, if you could have your client sign that. Because this is a plea bargaining agreement, because I followed your plea bargaining agreement, and because you waive your right to appeal, you do not have the court's permission to appeal.
Yes, ma'am.
Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes, I do, Your Honor.
Oh, that's your copy.
Oh, okay.
All right, good luck to you.
Thank you, ma'am. And again, I do apologize for wasting the court time. It was a very big misunderstanding.
Oh, let me just tell you, this is never wasted the court's time. This is what I'm paid to do, okay?
Okay, and my mother watches you all the time, Sylvia Morgan.
All right, tell your mom I said hi.
Well, she's probably watching.
All right.
Thank you, Judge.
Don't disappoint your mom anymore, okay?
I will not. Thank you so much, ma'am. I appreciate it.
All right, thank you.
Sir. All right, thank you. Do you have a quick one? I don't have one. Do you have- they were here? Okay, good. Thank you so much.
All right, Ruth Trevino. Yes, come forward.
Thank you.
All right, so what are we here for?
Judge, this is the second time Mr. Trevino has appeared before the court with a warrant that we're trying to get withdrawn. On October 16th, her case is set for hearing. He wasn't notified. I wasn't notified. Her bondsman wasn't notified. I just don't know what's going on with this. But
All right, so here's the thing. It shows, okay, her case has been indicted. Who's your bondsman? All right, so you need to find out, and if you want to call Cowboys, we'll have her remain in the court. If you want to call Cowboys to see if if they want to be on her bonds. Because, and here's the thing. She was set on August 13th, 2024. And there was an issue there. And so I asked that the warrant be recalled and the bond was reinstated. The defense attorney contacted the bondsman and the bondsman agreed to get back on the bond. So I don't know why there's an issue and what's going on. I do understand that her case was indicted and she had an appearance on the 16th, October 16th. Okay. So you need to see if the bondsman wants to be on her bond. And I will tell you, I show people a little lenience when I see that it's the first time that they've been on the docket, because I know there are some issues with the Odyssey, potentially. So the question is whether or not the bondsman wants to be on her bond. So she's going to have to remain in court and just sit in the gallery. And you'll need to contact the bondsman and see if the bondsman wants to be on her bond. Okay, you're welcome. And then on, could I see the file on Justina Salcedo, please?
She was here yesterday downstairs and she's here.
Okay.
We came in asking for more.
All right, just one moment.
Spending with them. Those are the private.
I can't interfere with that. Hello? All right, so then what we'll do is we'll bring the jury in. And I'll have you state rest in front of the jury, and then defense, you can rest, then both sides can close. And then I'll send them back. Have both parties reviewed the jury chart?
We are doing that now, Your Honor.
All right.
And I do believe both sides may have some, if we could confer about it for just a few
Sure.
moments. Thank you, Judge.
All the jury, okay. We're going over the docket now. So. All right, state defense,
Yes, Your Honor.
defense. All right, do y'all have any objection if I let the jurors know that we're not gonna start exactly at 10, but that when we bring them out, that you all will do your closing arguments?
No, yeah.
All
No,
right,
no.
that way they won't think they're just waiting.
Yes, Judge.
A little bit about.
All right, can I see your client, please? Where is her paperwork? Ah, here we go. Yaya?
She's not.
We will stay until it is done. And then I'm gonna give you a reset form, so you'll know when to be here. Let me go. On Odyssey and see if they've given you a date. They may not have. Oh, no problem. So on this case, Ruth Trevino, the bondsman does want to remain on the bond. And the question is whether or not it's possible. Has it gone into forfeitures where you can't recall it? And
For what?
yeah, and I'll give you the cost number. Okay. The bonds, yes, and the bondsman, according to the attorney, the bondsman said they want to stay on the bond.
Okay.
Okay, thank you. All right, so what we'll do is we'll reinstate the bond. And this is gonna be recalled for December 9th. Could I get a reset form, please?
Paragraph 1. They will check.
All right, so you're gonna be back on December 9th. I'm giving you a reset form so you will know when to be here.
Also, David, on policy to make sure.
All right, thank you. And on this reset form, if your client can also put her email address. To your counsel, you still put her email address on that. All right, and Deputy Laura, the warrant is being recalled. Welcome. All right, then you are excused. Have a great day. You're welcome. All right, have a good one.
Thank you. I really appreciate it.
All right, you're welcome. All right, thank you, Yaya. Here are these documents. All right, and then Michael. We're gonna find out. Deputy Mejia, can you bring her out, Justina Sauceda? Is she downstairs? All right, thank you. Mhm.
Those sunflowers real, those are beautiful.
Yeah, they're real. Yeah. Yeah, these one I need to spray because you have to spray them at the top, because that's where they take the water instead of the bottom. All right, everyone. We're back on the record and 2022 CR 1331 State versus Raymond Alejandro. Can I have parties announced for the record? State,
Colonia for the state.
Ashley Jones for the state.
defense.
Matthew Allen. Jonathan Chavez. I'm ready to go.
All right, so have both parties had a chance to review the charge of the court? State,
Yes, Your Honor.
defense?
Yes, Your Honor.
All right, defense, any objection to the charges presented?
No, Your Honor.
State, any objection?
No objections.
All right. Then what we will do is both parties will rest and close in front of the jury. Then we'll proceed right into the charge of the court. It's the court's understanding that both parties are asking for 20 minutes. Is that correct?
Yes, Judge.
All right, any time announcement requested from the court?
5 minutes.
2 minutes for the state.
Okay. Just 1 second.
Yes.
All right, so do y'all want to wait until Mr. Allen comes back? Or are you okay with resting and closing in front of the jury? And then I'll read the charge.
Wait till Mr. Allen comes back.
Okay. It should take about 10 more minutes.
Mr. Saldana, if you can remember to keep your voice up. Otherwise, I'll just be writing what I think you're saying.
I think during opening and closing, I talk louder, but it's so direct where I kind of.
I think one mic works better than the other
Test 1, 2.
to get close to
Yes.
it.
That's sort of
Do
weird.
you want me to give you the wireless?
Does she have that?
I was just wondering, like, as far as like when you give a time
Does
announcement
she
to
have it?
the.
No, well, I'm not
to the
asking more
attorneys,
questions. It's gonna
as
be
to sort of where they're at in their time.
Do you want to?
Like a
The
5
mic,
minutes,
the
I understand
wireless?
it's requested at 5 minutes. I just didn't know. if it
Yes,
was
Maria,
anything.
what she wants.
No, no, they haven't.
Would you want him to play the wireless?
2 minutes, just-
No.
That's over the system.
Yeah.
I said if he wants to. I
Can
don't know
you-
How that works.
Yeah, it
I don't know if it detaches and what that or that. Hold it.
Oh,
It's up to Mr. Saldana.
It's like I'm gonna be singing.
What did we put on the table when you get on it?
Why wouldn't you just use it?
They didn't run, they're not gonna run out of batteries like they did.
All right. All right, so we're gonna bring the jury in, deputy.
I'm not gonna use that.
Test 1, 2.
No, that's for him to carry, not leave it on the
Otherwise you
table.
get feedback, yeah.
Test.
It's gonna be karaoke.
Just put it voice up.
It feels. Yeah.
I'll talk loud enough.
Yes,
Okay,
Without
thank
that.
you.
Yes, I have probably hearing you.
All right, for the jury.
All right, everyone, please be seated. Ladies and gentlemen, where we left off yesterday, there was a witness on the witness stand. It's my understanding that the state, you had no further questions of the witness, is that correct?
That's correct, Judge.
And defense, it's the court's understanding that you had no further questions of the witness, is that correct?
Yes, Your Honor.
All right, state, call your next witness.
The state rests.
Defense,
The defense rests.
state, do you close?
State rest and close.
Defense, do you close?
Yes, Your Honor.
All right, ladies and gentlemen, I'm going to read to you what's entitled the charge of the court. You do not need to memorize this because you will have the original back with you when you begin your deliberations. Charge of the court. Members of the jury, the defendant, Raymond Alejandro stands charged by indictment with the offense of indecency with a child by sexual contact alleged to have been committed on or about the 21st day of February 2021 in Bexar County, Texas. To this offense, the defendant has pleaded not guilty. 1. Our law provides that a person commits the offense of indecency with a child by sexual contact if, with a child younger than 17 years of age, whether the child is of the same or opposite sex, and regardless of whether the person knows the age of the child at the time of the offense, the person engages in sexual contact with the child or causes the child to engage in sexual contact. 2. Child means a person younger than 17 years of age. Sexual contact means any touching by a person, including touching through clothing of any part of the genitals of a child, if committed with the intent to arouse or gratify the sexual desire of any person. 3. A person acts intentionally or with intent with respect to the nature of his conduct or to a result of his conduct when it is his conscious objective or desire to engage in the conduct or cause the result. A person acts knowingly or with knowledge with respect to the nature of his conduct or to circumstances surrounding his conduct when he is aware of the nature of his conduct or that the circumstances exist. A person acts knowingly or with knowledge with respect to a result of his conduct when he is aware that his conduct is reasonably certain to cause the result. 4. The phrase on or about means that the state is not required to prove that the alleged offense happened on that exact date. Our law provides that the time of the offense alleged in the indictment must be some date anterior to the presentment of the indictment and not so remote that the prosecution of the offense is barred by limitation. There is no limitation period for the offense of indecency with a child by sexual contact. The indictment in this case was filed on February 8, 2022. 5. Now, if you find from the evidence beyond a reasonable doubt that on or about the 21st day of February 2021 in Bexar County, Texas, the defendant, Raymond Alejandro, did intentionally or knowingly engage in sexual contact with Jesus Leza, a male child younger than 17 years, by touching part of the genitals of Jesus Leza while on the bed with the intent to arouse or gratify the sexual desire of any person, then you will find the defendant guilty of the offense of indecency with a child by sexual contact as charged in the indictment. If you do not so find beyond a reasonable doubt, or if you have a reasonable doubt thereof, you will find the defendant not guilty. Evidence that the defendant has committed a separate offense of indecency with a child by sexual contact may be admitted in the trial of an alleged offense of indecency with a child by sexual contact for any bearing the evidence has on relevant matters, including the character of the defendant and acts performed in conformity with the character of the defendant. Your verdict must be unanimous. With regard to any evidence presented of a separate offense of indecency with a child by separate contact, if any, you're instructed that your verdict must be unanimous about the specific instance elected by the state as herein instructed that constituted the commission of the offense alleged. Our law provides the defendant may testify in his own behalf if he elects to do so. This, however, is a right accorded to the defendant, and in the event he elects not to testify, that fact cannot be taken as a circumstance against him. In this case, the defendant has elected not to testify, and you are instructed that you cannot and must not refer or allude to that fact throughout your deliberations or take it into consideration for any purpose whatsoever as a circumstance against him. You are instructed that you must not communicate with or provide any information to anyone or receive any information from anyone by any means about this case. You may not use any electronic device, or media, such as telephone, cell phone, smartphone, iPhone, BlackBerry, iPad, tablet or computer, the internet, any internet service, or any text or instant messaging service, or any social media platform, internet chat room, blog, or website to include, but not limited to Google, Facebook, MySpace, Instagram, Snapchat, LinkedIn, YouTube, TikTok, Twitter, or X to communicate with anyone, any information, or receive any information from anyone about this case, or to conduct any research about this case until I accept your verdict. Written statements made by a witness to investigators or other officers, or police reports made by officers and tendered by the prosecution to the defense for purposes of cross-examination are not part of the evidence unless introduced in evidence. Many times, statements and reports may be marked with an exhibit number, but are neither offered nor received in evidence. I can send only statements and reports received in evidence to the jury room. You are instructed that the statements of counsel made during the course of the trial or during the argument, if not supported by evidence, or statements of law made by counsel, if not in harmony with the law as stated to you by the court, and these instructions are to be wholly disregarded. You must disregard any comment or statement made by the court during the trial or in these instructions, which may seem to indicate an opinion with respect to any fact, item of evidence, or verdict to be reached in this case. No such indication is intended. You are instructed that the grand jury indictment is not evidence of guilt. It is the means whereby a defendant is brought to trial in a felony prosecution. It is not evidence, nor can it be considered by you in passing upon whether this defendant is guilty or not guilty. During your deliberations in this case, you must not consider, discuss, nor relate any matters not in evidence before you. You should not consider nor mention any personal knowledge or information you may have about any fact or person connected with this case, which is not shown by the evidence. You are instructed that you are not to let bias, prejudice, or sympathy play any part in reaching a verdict in this case. After argument of counsel, you will retire to the jury room, select your own presiding juror, and proceed with your deliberations. After you have reached a unanimous verdict, the presiding juror will certify thereto by filling in the appropriate forms attached to this charge and signing his or her name as presiding juror. You are the exclusive judges of the facts proved, of the credibility of the witnesses, and of the weight to be given to the testimony, but you are bound to receive the law from the court, which is herein given to you, and be governed by that law. In order to return a verdict, each juror must agree to that verdict, but jurors have a duty to consult each other and to deliberate with a view to reaching unanimous agreement, if that can be done without violence to individual judgment. A unanimous vote means all 12 jurors must agree. Each juror must decide the case for himself, but only after an impartial consideration of the evidence with his fellow jurors. In the course of deliberation, a juror should not hesitate to re-examine his own views and change his opinion if convinced it is erroneous. However, no juror should surrender his honest conviction as to the weight or effect of the evidence solely because of the opinion of his fellow jurors or for the mere purpose of returning a verdict. All persons are presumed to be innocent, and no person may be convicted of an offense unless each element of the offense is proved beyond a reasonable doubt. The fact that a person has been arrested, confined, or indicted for, or otherwise charged with the offense gives rise to no inference of guilt at his trial. The law does not require a defendant to prove his innocence or produce any evidence at all. The presumption of innocence alone is sufficient to acquit the defendant unless the jurors are satisfied beyond a reasonable doubt of the defendant's guilt after careful and impartial consideration of all the evidence in the case. The prosecution has the burden of proving the defendant guilty, and it must do so by proving each and every element of the offense charged beyond a reasonable doubt. If it fails to do so, you must acquit the defendant. It is not required that the prosecution prove guilt beyond all possible doubt, It is required that the prosecution's proof excludes all reasonable doubt concerning the defendant's guilt. In the event you have a reasonable doubt as to the defendant's guilt, after considering all the evidence before you and these instructions, you will acquit him and say by your verdict not guilty. Suitable forms for your verdict are attached to the charge for your convenience if you care to use them, but they are not intended to suggest to you in any way what your verdict should be, and you may or may not, as you see fit, make use of them. At any rate, your verdict must be in writing and signed by your presiding juror. Your only duty at this time is to determine whether the defendant is guilty under the indictment in this cause, and you must restrict your deliberations to the issue of whether the defendant is guilty or not guilty and nothing else. After you have retired to the jury room, no one has authority to communicate with you except the deputy who has you in charge. Do not attempt to talk to the deputy or anyone else concerning any question you may have. Instead, address your question to the court in writing. If you want to communicate with the court, notify the deputy. Any and all communications relative to the case must be written, prepared by the presiding juror, and submitted to the court through the deputy. Respectfully submitted, Judge Stephanie Boyd, 187th District Court, Bexar County, Texas, and suitable forms are attached. State, are you prepared to proceed?
We are, Your Honor.
All right, you may proceed.
Most of you, if I remember correctly, have children. And what we want most for our children is for them to feel safe, and we want them to feel loved. And the place that we want them to feel the most safe and the most loved is in their home, surrounded by their family, who they trust, who they love, and who accepts them for who they are. Jesus had that. He had that with his stepfather, with his mother, with his siblings, and with the defendant, who he treated like a brother. They would hang out. They would play games together. The defendant would help out around the house. The defendant would take care of Jesus. That is until the defendant betrayed that trust in Jesus when he was 13 years old. When Jesus was 13 years old, the defendant came into his room. Let me just back up here. That is Jesus at 13 years old. He was a young man sitting with you on the stand today, but all of this happened back then. The defendant came into his room at night when he was by himself. He got on his bed, pulled down his pants, grabbed his penis, and started rubbing it. And Jesus told you what he was thinking in his head. He was trying to fight off any bodily reaction to that. And he struggled with it the entire next day. Should I say something? And he did. And because of Jesus's bravery, we are here today. But more importantly, you are here today to decide to give Jesus justice. And the judge gave you the law that you're going to use to do that. So I'd like to talk about it for just a moment. The state does have to prove all elements alleged beyond a reasonable doubt. And the elements that are alleged that you'll find in this jury charge are on paragraph 5. And that's going to state on or about the 21st day of February 2021. That's not really in contention. Everybody testified to that date. In Bexar County, Texas, everybody testified that the house that this occurred in, Jesus's bedroom, was in Bexar County, Texas, and that Raymond Alejandro committed these acts. Jesus pointed him out, Regina pointed him out, and Jose Garza pointed him out. What's in contention, of course, is what actually happened, what the defendant did. And that is what you have to decide from the evidence in the case. And so I want to make it clear that the only evidence that you're going to get back there with you to consider are the exhibits that were introduced in the trial. It's going to be the floor plan, Picture of Jesus on his gaming chair playing video games. Picture of Jesus. And the same records. Okay, that is all the evidence that you're going to get back there with you. But what's important is that you paid attention to the evidence that came from the stand. Because what did we say in jury selection? Testimony is evidence. You consider every single thing that you heard, and you use that along with these exhibits to come to your conclusion that the state's proved the case beyond a reasonable doubt. Now, Jesus also described a second incident. So I do want to get to that. That's going to be on the next page. The next couple paragraphs. The first one is what we call the second incident, okay? The second incident where Jesus talked about the defendant touching him while he was on his gaming chair. Okay, that is not what we indicted. The indictment covers what happened on the bed, okay, when the defendant came into his room at night. You do all have to be unanimous that that incident occurred. But you get to use the gaming incident where he was on his gaming chair to show that the defendant acted in conformity with his acts on the bed. You get to use that second incident to help you decide if the defendant committed the first one. And that's what these two paragraphs are talking about, okay? You heard from Jesus. He sat up here for hours under direct examination and cross-examination, bared his truth to you about how the defendant violated him, sexually abused him. And we are asking that you hold him accountable, hold the defendant accountable for those actions, and find him guilty. We'll reserve the rest for our time, Judge.
Defense, are you prepared to proceed?
Yes, Judge. Details matter, consistency matters, and investigations matter. What I told you in opening, and I think that came through in the entire trial. You and each of you do solemnly swear that in the case of the state of Texas against the defendant, you will true verdict render according to the law and the evidence, so help you God. That's the oath that you took, okay? That's the oath that you stand by sitting here today and in that deliberation room. We talked about beyond a reasonable doubt. There is no definition, okay? But what did we talk about? The different burdens of proof that we have in our country. And we talked about speeding tickets and probable cause, enough to get a warrant, to bring a case. Right? And that's what the investigator Salazar needed to push that case forward, probable cause. And we talked about civil lawsuits where people's property, their money is at stake, 50.001%, right? And then we talked about taking your children away. And I asked, well, how much evidence would you want? And I think we all agreed, man, you better bring it. You better bring the evidence to us so we can see it, if you're going to try to take someone's children away. And then we went further, the highest burden that we have, and that's what we have here, beyond a reasonable doubt. We talked about, well, why is that? Because we're talking about someone's life, their liberty, their freedom. Should the burden of proof be lower if the alleged crime involves a child? We all agreed no, right? Because of the ramifications of this type of allegation. Again, the burden of proof throughout, and you're gonna get tired of me saying it during this closing argument, but I'm gonna keep saying it because it's so important. Beyond a reasonable doubt. It's not, well, maybe this could have happened, maybe, probably, I don't know. That's not beyond a reasonable doubt. Okay? Again, the burden of proof in all criminal cases rests upon the state throughout trial. It never shifts. So again, those questions that you may have, man, I wish I could have heard from that person or seen this.
That burden lies with the state of Texas. And the judge just read to you the instruction, you cannot allude to, refer to, even think about or consider the fact that Raymond chose not to testify. And the judge gave you examples why someone wouldn't testify. Well, maybe you don't come off good at public speaking. Maybe the state didn't prove the case, so why even get up there, right? The judge showed you many examples of why. So again, if one of your jurors says, well, and alludes to that, you have to shut it down right there. So there's three possibilities: not guilty, guilty, and where a lot of you may be sitting right now. I don't know. Based on the testimony and the evidence that I got, man, I don't know. And we all said, what does I don't know mean? That means not guilty. Because why? Because the state did not prove that case beyond a reasonable doubt. Again, all persons are presumed to be innocent, and no person may be convicted of an offense unless each element of the offense is proven beyond a reasonable doubt. Okay, and that stays with Raymond throughout the entire trial. During your deliberations, you must not consider, discuss, nor relate any matters not in evidence before you. It's just what came from that witness stand and those few exhibits that you'll have in front of you. That's what you have to decide. Did the state take me to that place? Did they get me to beyond a reasonable doubt? Did they get me to 50.001%? It's not good enough. Did they get me enough to take someone's children away? Not good enough. Beyond a reasonable doubt. Speculation. There's no assumptions. There's no guessing. Any gap you have is filled in with the presumption of innocence. Your job, you decide the credibility of the witnesses. All right? Judge Boyd read you that jury charge. Don't worry, you're going to have it in front of you. So, what the state will ask, and I think what they asked already, use your common sense. I agree. But again, your common sense probably has some gaps and questions. Those are filled by the presumption of innocence. Protect the community. Children need to be protected. Again, this isn't a trial about this side wants to protect children and this side doesn't. We don't need to be here for that. Excuse his memory and inconsistencies. He was young. It was a long time ago. Some of that stuff doesn't go to the elements. We talked about this. That's how you judge credibility. And we know it's important. Details matter and consistency matters. You're instructed that you're not to let bias, prejudice, or sympathy play any part. Look, no one wants to see anyone, let alone a juvenile, sit on the stand and answer uncomfortable questions. No one does. No one wants to see a family split up, crying in the courtroom. No one does. At the end of this case, whether you vote guilty or not guilty, there are no winners. Okay? That is not what you're here for. Again, you are here to judge the evidence in this case. It's not who you feel sorry for. If you didn't like the way I questioned Jesus, take that out on me, please. Do not take it out on Raymond. I wanted to make sure that you guys could judge the credibility. So again, it's not about who you feel sorry for. There are no winners in this case. Julie Vereen. She said, well, there's concern for sexual abuse. Well, anytime someone says that they were sexually abused, there's going to be concern. There's a normal finding. She didn't tell you anything to support a sexual assault. She didn't attempt DNA. She recommended some further things that you'll see on there. But we didn't hear about any of those. So what did she really tell you? It could have happened. It may not have happened. It's just as consistent. Okay? The investigation. The deputies made a decision to charge Raymond less than an hour. They didn't try to collect any physical evidence. They did nothing to corroborate anything that was being said. And we talked about, well, is it easy or difficult to make an accusation? Well, you saw how easy it was. They made a phone call about a general allegation. The police come out there with the mindset, we don't want to re-traumatize the victim. So they're already a victim, and we don't want to ask too many questions, right? We don't want to get too many details. We're going to file a case and put out a warrant. That's what the deputy said. He said, well, I didn't mean that. What I meant was, we're going to do a full and thorough investigation. Is that anywhere near one another? It's not. Did that full and thorough investigation come to fruition? It definitely did not. So the deputies, again, they're out there, no one's crying. They asked some basic questions, they left. And talked about, well, we're not forensic interviewers, so we don't want to ask those questions. And the deputies, well, we can't make decisions on investigation. Okay, so they passed the buck down the line to now Sergeant Salazar. She had to try multiple times to contact Regina Garza. Someone who said that their child was abused. The sergeant has to reach out to you multiple times. And I'll never understand. And Sergeant Salazar told you, I can't, it's strange to her. She can't understand it. They're on the same phone plan, but they can't give a phone number. They can't give an address. That she was concerned about the family's lack of cooperation. Again, she goes out with a mindset, she doesn't want to upset the victim. She doesn't collect evidence. But she told you, well, I got a lot of my information at that forensic interview 3 weeks later. So you're making a decision based on you not asking specific questions and then hoping that it's going to stay the same 3 weeks later. Again, it's sloppy, it doesn't make sense. Obvious bias and zero regard for the presumption of innocence. One of the biggest concerns and frightening things for our community didn't include things in the prosecution guide about the family because it would lend doubt. Does that sound like someone's unbiased? Doing a thorough investigation? What else did she leave out? Again, she's concerned the family's hiding something. She wanted more information. Again, all she needs is probable cause to file a case. She sends that case to the DA's office. Regina. So after her son tells her that he was sexually assaulted, she goes to her husband's room and leaves her son in his room by himself while the supposed perpetrator is out there. Doesn't really make sense. She said that she made Jesus repeat the allegation to his stepdad. His stepdad and Jesus didn't say that. Again, that doesn't really make sense. So let's talk about some differences here. Again, the phone number. Regina, I gave him the phone number. Salazar and the deputies, we didn't get a phone number. Those aren't like minor detail inconsistencies. Someone is lying. Ask for an address. Well, we could at least give the location. Sergeant Salazar said, if I gotten a location, I would have gone over there. Well, we know that didn't happen. Oh, he was at a friend's house, or they didn't know. Well, they knew that he was at his mom's house. Again, didn't know the address. A police officer can't find his own mother's address? Come on. People usually call immediately and follow up with me. They never gave a reason why they didn't, or why Sergeant Salazar had to keep coming to try to find them. The deputy was told Regina didn't want to take him to the same exam. I asked Julie Vereen, who's a nurse, we asked other people, yeah, if someone's saying that, they need to be taken to the same exam immediately. Jesus couldn't remember a lot of details or what was said. Different reactions to different people asking questions. Okay? And that's just a fact. That's what happened. At first, it's a general allegation. Okay? Yesterday, using some language you've never used before to describe things. So, Jesus says, I initiated the conversation. Regina says, I did. Jesus, his mom told him to go to sleep because of school. Well, there's no bedtime on the weekend, and we knew that there's not school the next day. Vividly remembers, mom told me, oh, well, okay, there wasn't school. She told me to go to sleep because my circadian rhythm. Regina never said that. He said he spoke in general terms at first. Regina was positive. He used the term masturbated. Jesus says, I don't even know what that term meant back then. Jesus, my mom really didn't ask follow-up questions. Regina, I did ask follow-up questions. Again, Jesus, I didn't tell my stepdad, well, then he couldn't remember. Regina. No, I made him tell his stepdad what happened. Again, some of these don't go to the elements, but these are important. These are huge details. These are not, well, I think I was wearing a yellow shirt. It might have been green. No, these are important details that we know matter. Jesus, I heard footsteps previously. Then when he testifies, no mentioning of footsteps. Okay, previously, no mention of knocking. Oh, yeah, specific, knock twice, exactly like this. Didn't you say at one point, knock 3 times? Oh, yeah, I did. Okay. Pretend to be asleep so he wouldn't get in trouble. Well, he also said his mom usually doesn't come check on him. Well, he says he opens his eyes and sees Raymond. So it's not his mom, yet he's still pretending to be asleep. Again, watching TV. Then he testified while I was playing video. Oh, I meant watching TV. Okay. And if you took these single by themselves, that was it. Watch TV, video games. All right. It's not, maybe not a big deal, right? But we're not talking about 1 or 2 or 3 or 4 or 5 inconsistencies. We're talking about throughout his entire testimony. Under the clothes. Well, maybe it was the flap in the boxers. Oh, he pulled pants down to his thighs. Again, that's an important detail. First time using the word ejaculated, and I'm sorry, still didn't know what it meant. Using word in any case, but in a case like this, when you're using specific terms and you still don't know what they mean, it's dangerous. And that's what you're supposed to rely on. He was piecing his story together, right? At one point he said, well, the bedtime thing. Well, all 3 could be true. Great. Tell me which one was. He came into the room and sat in a chair. Oh, wait, yeah, he sat next to my game chair. Oh, he laid on the floor. And the prosecutor's like, well, I mean, did he just come in and sit next to him and then lay on you? Oh, yeah, that was it. Laying his, oh, you can look at that gaming chair, and they talked about the size of Raymond, him laying his head on him on that gaming chair. I mean, that is uncomfortable to say the least. Again, here are the steps in the hall versus the knocking. I mean, you could see him up there. He goes, well, you're right. I must have heard the steps. Because if it was knocking, I wouldn't have been able to turn off the game. So I must have heard the steps. But he also must have knocked. Which one is it? Not after the gaming incident. He doesn't remember who walked out first. Again, it's not even saying I don't remember. It's telling you something specifically.
5 minutes.
Thank you, Judge. And then later on saying, well, I'm not sure. Maybe. Okay, lay in bed in your feet. Didn't know which hand. Because he's not looking, but he did. And then a silhouette versus an actual person. Well, yeah, I mean, I saw him. I peeked. Maybe I saw both. So again, just there was little regard for the ramifications of what he was testifying to under oath. Prior, no physiological changes. Fighting, had an erection, and it said, yeah, you're right. I lied last time because I was embarrassed. Well, then I asked him like 20 minutes later, and he couldn't even remember what he had testified to. That is an important detail. If you don't know something, you don't just answer it. You say, I'm not sure what you're asking. And he did that with me. Prior under oath. I mean, I hope you guys caught it because this is huge. Under oath, after the bedroom incident, he says, I didn't see Raymond again. What does he do this time under oath? He gives you another story about a gaming chair and game incident. That's not a minor detail. That's an entire allegation. It's not something that you forget. It's not something that you say, well, again, I wasn't sure if I had shorts and a shirt on or if I just had shorts. No. This is an entire allegation. Under oath. Do we always know why someone would make an accusation? Talked about this. We don't. And each of you said you're not going to require the defense to show an ulterior motive. So I don't know. There's a new family. There's new children. The parents are always working.
2 minutes.
Thank you, Judge. It's a teenager. Maybe he doesn't understand the ramifications. I don't know. All right. I'm not going to sit here and pretend that I do. I'm trying to give you some examples. But again, we don't know why. And each of you said that you would not require us to prove it. But what we do know, he didn't understand what he was saying back then. And he still doesn't really understand what he's saying now. Is it easy or difficult to recant? Again, police are called. Raymond's out of the house. Police are called immediately. The family, within minutes, is basically torn apart. You think it's easy to come back and say, maybe I didn't know what I was talking about? No. Common sense. Raymond had all this time where he's watching the kids and both parents are away. He's living there at the house. He's hanging out, him and Jesus. But he waits. He goes, you know what? 5 a.m. on a Sunday when the family's home, and in the middle of the afternoon when the family's home, that's when I do it. When the door can't lock, the entire family is home, when he could yell and everybody would wake up, when a 1-year-old is sleeping there. We know how 1-year-olds sleep, not very well. When his younger brother might have been awake right next to him, 10 to 12 feet away. When there's a police officer in the hall, down the hall with a gun, and he knocks on the door to announce that he's coming, but then sneaks in after. Use your common sense. Again, the burden of proof, I told you I was going to bother you again. Don't worry. After I sit down, the state gets to talk. Even if I wanted to, I can't come up here and talk anymore, which I'm sure you guys are glad. But just take this back there, okay? Think about it. Does this make sense? Not who do we feel sorry for? And when you look at this case and you look at the evidence and the testimony that you received in this case, did they get you to 50.001%? Did they get you to a point where you would take someone's children away based off this? They didn't. They did not get you to the point of beyond a reasonable doubt. And because of that, the only verdict in this case that you can return, what I'm asking, is to return a verdict of not guilty. Thank you.
Remember during jury selection, I asked everybody, think of the first sexual experience that you went through. And a lot of you paused for a second, and it may have felt uncomfortable because you probably thought I was going to call on you to talk about that experience. Do you think testifying about a sexual experience was easy for Jesus? Do you think it was uncomfortable to sit on the chair and try to remember or talk about probably the most embarrassing experience that he has gone through in his life, that not just affected him, but his family as well? Jesus understood the gravity of what he was going to tell his mother. He took a full day to make a decision, to say something, to speak up, because he knew that if he did, there was going to be a cost. And that is that it would break the family. But he also knew one thing. What he did was wrong and unacceptable. And that is why he told his mom when he came back from school that Monday afternoon. Regina told you how she felt about the defendant, how the relationship, how she thought of him as a son. She trusted him. Imagine how a mother feels when your child comes to you with this information. She had no choice, but she had to protect her son. So she tells Jose, her husband. And what does he tell Jose? You need to get him the fuck out of here. Why? Because she was upset. She's mad. But she also had to not react because there's so many emotions coming to your head. She tells her husband goes to the master bedroom and calls his brother because he told you too. He was angry. He was upset. But he also didn't want the emotions to come for you because he is a police officer. And yes, ladies and gentlemen, there are guns in the house. So he called his older brother. You need to get him out of here. So the older brother comes in and picks him up. And then Regina calls the police. Does that make sense? Yes. So when the police arrives, you have Deputy Hernandez, and he told you his main job is to collect the general information to determine whether or not there was an offense that was committed. His role is not to investigate. If the case has the merit, he refers it over to CID, Criminal Investigations Division, and an investigator gets assigned. So the investigator is Sergeant Salazar, and you heard from her as well. As she told you about the investigation, she told you, well, we referred him over to the hospital for a say. We referred him over to Child Safe for a forensic interview. I obtained a statement from Regina, the outcry witness. She told you, I observed the forensic interview. I was present during that. She reviewed the SANE records. And she also told you about, yes, the attempts that she made to locate the defendant and how she was unable to find him. Maybe because he doesn't have a permanent place. Maybe he was with his mom. Now, keep in mind that the investigator submitted the case in May. There's no decision about this warrant. The case was sent to the DA's office. Yes, Regina did provide testimony. I gave the investigator the phone number. And then the investigator said, I did not get any phone numbers. I can't tell you who's right and who's wrong. But I will point out this. Sergeant Salazar did testify that she had a large caseload. And she also told you that she would write notes and sticky notes and Post-its. And that she couldn't recall if she left voicemails. Mom, they're suggesting that she didn't cooperate, or the investigator said that she wasn't cooperating. Well, does that make sense? She reported it. She got him out of the house. She took him to get a SANE. She took him to Child Safe. She came here and testified. Does that make sense to you that she's not cooperative now? Now, is it possible that Sergeant Salazar may have misplaced the phone number or the sticky note because she was moving offices, as she stated? Perhaps. But does that really matter? Does this really have anything to do with the elements? At the end of the day, the sergeant did what she could to make efforts to get a hold of him. She wanted to get a hold of him. It's not like she didn't. She did it clear. She obtained an emergency contact of mom and called her. She went on social media and tried to find them, but unfortunately there was no success. And yes, at the end of the day, ladies and gentlemen, we're not perfect. All right, and she took the stand. And yes, looking back, she would have documented her attempts better on her report. Now, not only did Jesus tell his family and the deputy about what happened, but he also went to get the SANE exam. And what did he tell you about the SANE exam? He felt violated. This is right after, a couple of days right after he was being touched. It was an uncomfortable procedure. And we provided to you the testimony from the nurse and the medical records. Defense brings up this argument about physical evidence not collecting. You're not going to find physical evidence. You're not going to find bodily fluids because there was no bodily fluids. Jesus comes in and he testifies, and you saw him demeanor wise, you make the determination. How he was, how he looked at, his body language, his tone. And he talked to you about two instances. In the indictment, we're charging with one count, we're referring to the bed instance, where there's skin to skin contact. The other instance of the being in the chair, in the game room, the game chair, that's additional information you can consider. Because guess what? The first instance was his way of testing the waters. And he did it again the next day. And had he not spoken up, who knows what would have happened again. Defense comes here and talks about different details that are missing. Remember juror number 10, he was actually sitting right there, and I asked juror number 10, what is your earliest memory? She remembers some things, but not other things. That doesn't mean it didn't happen. This did happen almost 4 years ago. The complainant was consistent. He spoke to his mom. You heard her testify. She told you what her son told her. She's the outcry witness. She's allowed to say what her husband, what her son tells her. That's what an outcry witness does. There's the exception to the hearsay rule. You heard testimony from Jose. Jose was consistent as well with the Sainers. You'll have those records. His narrative is there. You saw him on display. He was also consistent with Chelsea because he said, I told Chelsea the same thing.
Objection, facts not in evidence.
All right, ladies and gentlemen, you'll remember the evidence as it was presented to you.
I asked him, is that the same thing that you told the Sainers? He said, yes. I asked him, is that the same thing you told the Chelsea? He said, yes.
Objection, Judge, facts and evidence. That question was never asked.
All right, ladies and gentlemen, you'll remember the evidence as it was presented to you.
And of course, you heard his testimony today. One thing to consider is questions from defense are not evidence. My questions are not evidence. Remember during jury selection, anything that is not before you in the back is not evidence. But you know what is evidence? Testimony. Testimony is evidence. Okay? And Jesus's testimony is evidence. Ask yourself, when you consider his testimony, where's the motive? Where is the motive? What does he have to gain? There's no evidence that was presented here that points to a motive, and he conceded that. He said, I don't know what the motive is, but it could be this, this, and that, because there isn't any. In fact, he loved the defendant very much. He considered him his brother. He trusted him. The family trusted him. And how does he repay them? By betraying them. Especially Jesus. Ladies and gentlemen of the jury, the defendant must be held responsible for his actions. What he did was wrong and unacceptable. Jesus was a 13-year-old boy that was navigating the awkward phase of becoming a teenager and trying to figure out, who he will be as an individual. And on February 21st of 2021, the defendant made it even harder by making him a victim of sexual abuse. This is why here today I'm seeking justice for Jesus. I'm asking that you hold the defendant responsible, that you hold them accountable for his actions. Ladies and gentlemen of the jury, the evidence proves this case beyond a reasonable doubt. I ask that you find Raymond Alejandro guilty. Thank you.
All right, ladies and gentlemen, I'm going to have you go to the back with the deputy, and I'm going to ask that two of you remain behind.